Hi everyone, welcome back to Hands-Free Studying for the MBE with Brainscape. Today's video is about torts, so get ready and let's get started with our first set of cards covering intentional torts. Question 1. What are the prima facie elements of an intentional tort? The prima facie elements of an intentional tort are that first, there must be a voluntary act. Second, there must be an intent to cause harm. Third, there must be causation. And 4, there must be resulting harm. Question 2. What intent is needed for intentional torts? There must be an intent to cause a harmful result, or the defendant must act with knowledge that harm is substantially certain to result. Question 3. Are children and the mentally incompetent liable for their own torts? Yes, children and the mentally incompetent can be liable for their own torts when they have the intent required for the tort. Question 4. Define the doctrine of transferred intent. The doctrine of transferred intent holds that if a defendant intends to commit a tort but causes injury to a different victim or commits a different tort than intended, the original intent is transferred to the new victim or tort. Question 5. Transferred intent applies to which type of torts? Transferred intent applies to assault, battery, false imprisonment, and trespass to chattels or land. Question 6. What are the elements of battery? Battery requires an intentional act that causes harmful or offensive contact. Question 7. What qualifies as contact for battery? Contact for battery is touching either the plaintiff's body, touching something that has a close physical connection to the plaintiff's body, so that could be a purse or even a pet on a leash, or creating circumstances that will cause the plaintiff harm. For example, putting water on the stairs so that the plaintiff will fall. Question 8. What constitutes harmful or offensive contact for battery? Harmful or offensive contact is contact that either causes injury, pain, or any physical discomfort to the plaintiff, or any contact that would offend a reasonable person's sensibilities. Question 9. Does the plaintiff need to be aware of the contact to constitute battery? No, the plaintiff does not need to be aware of the contact to constitute battery. Question 10. Does the plaintiff need to prove physical harm for battery? No, the plaintiff only needs to show that the contact would be offensive to a reasonable person and that the defendant had the intent to cause that offensive contact. These upcoming torts questions cover negligence. Question 1. What are the elements of negligence? The elements of negligence are first, duty of care, second, breach, third, actual cause, fourth, proximate cause, and fifth, damages. Question 2. What general duty of care is owed? The defendant owes a reasonable duty of care. In other words, a defendant should act like a reasonably prudent person to all foreseeable plaintiffs in the zone of harm. Question 3. Who are foreseeable plaintiffs? Foreseeable plaintiffs are persons who are in the zone of danger, which is the area where the person is reasonably at risk of suffering physical harm from the defendant's conduct. Question 4. What are the different standards of care? The first is the reasonably prudent person standard, sometimes abbreviated as the RPP. And then we have standards that are imposed on children, standards that are defined by statute, standards defined by industry custom, and then you have different types of standards for professionals, landowners, and common carriers and innkeepers. Question 5. What is the reasonably prudent person standard of care? The reasonably prudent person standard states that a defendant must act as a reasonably prudent person would under the same circumstances with the same knowledge and capacity as an average person. Remember that this is an objective standard. All right, folks, let's take a quick study break to remind you how important negligence is for the MBE. It will make up half of all of your torts questions and account for roughly 1/14 of your overall MBE score. So make sure you pay close attention to negligence. All right, let's get started on those last 6 through 10 questions. Question 6. What is the standard of care for children? The standard of care for children is that children must act as a child of similar age, experience, and intelligence would in similar circumstances. Now remember that this is more subjective than the reasonably prudent person standard. Question 7. When are children held to the adult standard of care? Children are held to the adult standard of care, which is the reasonably prudent person standard, when they are engaging in inherently dangerous adult activities. For example, driving a car or motorcycle. Question 8. What is the standard of care for professionals? The standard of care for professionals is that they must act the same as a professional with the same expertise and experience who is in good standing in a similar community would act. Question 9. What is the standard of care for doctors? Doctors must act the same as an average doctor in good standing would act. Now, in some jurisdictions, they're compared to an average doctor in the same geographic area, and in other jurisdictions, they look at how an average doctor nationally would act. Question 10. What is the standard of care for specialists? The standard of care for specialists is a national standard of care for that specialty. These upcoming torts questions cover strict liability and products liability. All right, let's get started. Question 1. Strict liability is only imposed in which 3 scenarios? Strict liability is imposed in scenarios involving abnormally dangerous activities, wild animals, and defective products. All right, question 2. What type of duty does a defendant have in strict liability situations? The defendant has a duty to make the activities absolutely safe. The defendant will be liable for the plaintiff's injuries even if the defendant was not negligent. Question 3. What are the elements needed to establish a prima facie case for strict liability? First, you need to show that the defendant's activities imposed an absolute duty to make them safe. 2, that there was a breach of duty. 3, there was actual cause. 4, there was proximate cause. And 5, there were damages. Question 4. When is a defendant strictly liable for injuries resulting from a wild animal. The defendant will be strictly liable when the plaintiff's injuries are unprovoked and caused by the animal's foreseeable dangerous propensities or characteristics. Now, note, the defendant will only be liable for injuries caused by the animal's dangerous propensities. If the defendant owned a lion, for example, and the plaintiff is injured because she's allergic to the lion's hair, the defendant will not be liable because it's unrelated to the lion's dangerous propensities. Question 5. What is considered a wild animal? Wild animals are considered animals that are, as a matter of common knowledge, are naturally ferocious, unpredictable, dangerous, mischievous, or not by custom devoted to the service of mankind where they are kept. Let's take a quick study break to remind you that it's really important to sit up straight. Good posture improves your attention span and memory, not to mention prevents back problems. So let's sit up a little bit straighter and go through questions 6 through 10. Question 6. Are defendants liable to undiscovered trespassers for injuries from their wild animals? No, defendants do not owe a duty to undiscovered trespassers for injuries from a wild animal, but they may be liable for injuries from a vicious watchdog. Question 7. Is a defendant strictly liable for injuries caused by domesticated pets? Generally, no. The defendant will only be liable for negligence. However, if the defendant knows or should know of the animal's dangerous propensity, and the plaintiff's harm is caused by that dangerous propensity, then the defendant can be held strictly liable. Question 8. Is a defendant strictly liable for harm caused by his animal trespassing on another's land? Yes, the defendant can be strictly liable for reasonably foreseeable harm. There is an exception, however. The defendant will not be strictly liable for damage caused by household pets. Question 9. What is considered an abnormally dangerous activity? Abnormally dangerous activities are defined as activities that are not of common usage and that create a foreseeable and highly significant risk of physical harm, even when reasonable care is exercised. In other words, this activity is so dangerous that it cannot be performed safely no matter how much care the defendant exercises. Question 10. What are some examples of common abnormally dangerous activities? Some examples include blasting, mining, transporting toxic waste, fumigating, or using explosives. Remember, this is not an exhaustive list. These are just some things that may come up on the MBE. These upcoming torts questions cover other types of torts, including nuisance, defamation, misrepresentations, vicarious liability, and joint and several liability. Question 1. What are the elements of a public nuisance claim? The elements for a public nuisance claim are that 1, the defendant unreasonably interfered with a public right, typically the right to health, safety, or property, and 2, the plaintiff suffered a distinct and different harm from the public at large. Question 2. Who has standing to bring a public nuisance claim? It's most common that the government will bring a public nuisance claim, but an individual can also bring a public nuisance claim if they can show that they are suffering a distinct and different harm from the public at large. Question 3. What are the elements of a private nuisance claim? To prevail on a private nuisance claim, the plaintiff must show that there's been a substantial and unreasonable interference with the plaintiff's use or enjoyment of her land. Question 4. What constitutes substantial and unreasonable interference in regards to a nuisance claim? The courts define substantial as offensive, inconvenient, or annoying to a reasonable ordinary person. And unreasonable is defined as an injury that outweighs the utility of the behavior. Question 5. What are the remedies for a nuisance claim? There are 2, injunctions and damages. Question 6. Differentiate between nuisance and trespass. For a nuisance claim, no physical invasion is required, which means that you can prevail on nuisance claim for light, for smells, etc. A nuisance claim also needs to be continuous, and there needs to be substantial interference. On the other hand, for a trespass, physical invasion is required. It does not need to be continuous, and it does not need to be substantial interference, unlike a nuisance claim. Question 7. What are the elements of defamation? To prevail on a defamation claim, you need to show that there was a defamatory statement concerning the plaintiff published to a third party that can either be intentionally or negligently, that damages the plaintiff's reputation, and then if the matter is of public concern or the plaintiff is a public figure, you must also show that the defendant acted with malice. But remember, this is only if the matter is of public concern or if the plaintiff is a public figure. Otherwise, all that you need to show is there was a defamatory statement concerning the plaintiff published to a third party that damages the plaintiff's reputation. Question 8. What are the 2 types of defamation? The 2 types are libel, which is written defamation, and slander, which is spoken. Question 9. What types of statements are considered defamatory? Defamatory statements are those that diminish respect or goodwill towards the plaintiff or deter third parties from dealing with them. Question 10. What types of statements are not considered defamatory? Non-defamatory statements include hyperbole, which are statements that no reasonable person could possibly believe that they're true, and also opinions, because opinions cannot be proved true or false. However, there is an exception. If the speaker implies knowledge of facts when giving an opinion, it could be considered defamatory.
And that's the end of your study round. To reach full mastery, remember to study in Brainscape. Our mobile and web app uses the latest in spaced repetition techniques, allowing you to optimize your study time and track your progress down to the finest detail. But of course, when you're driving, cooking, exercising, or otherwise unable to navigate the app, be sure to keep listening to the rest of this hands-free studying playlist. No matter what subject you're learning and what method you're studying it, Brainscape helps you rise to your challenge.